So, for all you people who thought that the Supreme Court was out of control when they got rid of the presumption of competence by the EPA in lawsuits about regulation and other actions, before that presumption, people would go to court to settle environmental issues. That was always the last step in a regulation. Somebody, that the court would decide it. And the courts, the reason that the presumption of competence was put in because the courts didn't feel that they wanted, the court didn't feel that they wanted individual trial judges to be in control of environmental policy. Guess what? There are going to be a lot of, every time there's a regulation changing environmental policy, there will be citizens who now can say, we object, and the EPA, who may actually have to gut some policies, or Department of Energy or whoever, will be challenged in court by the good guys who will say the court does not have to presume that what the EPA says is correct, because it might not be. So, in a world where the Democrats are in control forever, then, or reasonable, neoliberals, Republicans are in control forever, the presumption that the government is correct technically, is reasonable. But now that it may not be when it's up to the 48th president of the United States, or 50th president of the United States, we could get to that, or 49th president, that it's suddenly not a bad tool to have if you're an environmental lawyer, to be able to now that the Republicans are in charge, and the Project 25 Republicans are in charge of environmental policy. Suddenly it's a very good tool to have if you're an environmental lawyer, to say, well, we don't believe the EPA's data. We want to challenge it with our own witnesses. We can't presume they're correct. So for all those who thought that decision was the worst ever, told you so, because I did. It's like for the affirmative action plans. The reason they get rejected is they haven't submitted any good ones. It's not that John Roberts is being partisan. It's that the plans that have been put in to date are crap. Random selection is the best plan. And when people finally start doing affirmative action plans with random selection of the middle ones, the medianly qualified, there's always the very, very well qualified who will, they'll compete for. But then you get down the scale, especially if you can get rid of legacies, and the existence of legacies is a reason to include them in random selection too, because that's something that you can bring in as a point if you're doing an affirmative action plan. But that would mean that the people have to be against, universities have to be against legacies, and that may not happen. But using random selection will always give you a representative sample of your applicants. It's the best form of affirmative action. It takes the onus out of a quota system and out of enrollment committees, reviews, selection committees. You totally get rid of them and say, okay, we've decided who's qualified and might be able to make it. We're keeping the really good ones, and we've gotten rid of the really bad ones. Everybody else, we're going to pick a number, and we'll have a lottery, like they do with school choice. So, that is the answer. if somebody puts that plan in, the Supreme Court will say, yeah, see nothing wrong with that. So you just have to have the right plan. It's not because, the majority of Republicans are bigots. It's because no good plans have been put in. That's the plan I just described. That's the plan that will succeed, will pass the court's muster, and it will be representative of the applicant pool, of the qualified applicant pool. So, yeah, especially if legacies have to be in that pool too. And that would be the brave university who does that to their legacies. So, and the brave court who says you have to include the legacies in the pool. That might actually be a way to challenge plans that you don't like, that don't keep legacies out, that you could go to, if random selection produces non-discrimination, and by nature it does, all things being equal, then if a school uses legacies and that leads to discrimination, then the people who want to challenge that carve out, if you've got a better plan that again uses random selection, then they can sue and say, no, the legacies are a problem. And the court would have to agree, because objectively they are a problem leading to discrimination. But trying to work it all out with an administrative formula and a committee and all that, yeah, that doesn't ever fly. If you randomize the maybes and you include the legacy maybes in that, then your sample will be representative of the applicant pool, and do all of the things that affirmative action is supposed to do would be done that way. But you've got to put that in front. So all these. One final thing about judges or justices. The next two to go are Republicans. So you will, by definition, you will have better Republicans than Alito and Thomas, especially Thomas. They'll be like Comey Barrett, and Kavanaugh and Gorsuch, who don't necessarily vote with Thomas. Comey just tore on presidential immunity. She tore Thomas a new one. She did not go along in her concurrence with some of the logic of it, or the illogic of it. So yeah, she's becoming an independent thinker. She's becoming an O'Connor, what's that guy's name? The Bush appointee. You know what I'm talking about. She's going to move to the center and with Roberts and drag on the other two newbies who were Kennedy people. They clerked for Kennedy, who they clerked for a centrist or a conservative centrist. The only real idiots on the court are Alito and Thomas, and they're old, and it's and are likely to either retire or die before the next Republican term is over. So, justices is not an issue, because there will be an upgrade, and one of those people will be a liberal, because will be a moderate. It's usually a 1-for-1. You get a moderate, and you might get a conservative, or sometimes you might get two moderates. The younger generation, they're not like Scalia, and they're not like Alito, and they're not like Thomas. So yeah, not afraid of the judges, not at all. So yeah, that's I think the third piece. So yeah, and of course on abortion, both sides want a legislative solution. Well, they can get together and compromise, because the voting, even with the new Senate, they can't ram through what the right to lifers want them to ram through. And Donald Trump doesn't need to listen to those people anymore. So, yeah, it's going to, I'm arguing for non-gloom and doom thinking here. Now, we'll see what happens. And, you know, we live in interesting times, especially if Joe Biden wants to make sure there's a female president, and that female president's name is Kamala. He can find a way to retire early. And he will. If we ask him to, he will. He very much will. And, you know, and Kamala doesn't have to ask, and neither do we. He will do the right thing. So Kamala will be 47. Trump will be 48. And, you know, Trump's a tough old bird. He might actually, you know, surprise people. And if he's a senile old screw and does stupid things again, or says stupid things, you know, they'll control him. You know, the whole thing is Trump reacted against people trying to control him from the Republican side. The people were trying to came into the administration doing damage control. That will, if you've got a fragile ego, which Trump does, that will screw with your head. Now he's got again, you know, majorities in Congress, but not too big that they can get away with doing everything without some consensus. So, especially in the House. So, me not hearing who won the House tonight. I mean, it might be that, you know, the doors are going to come off. In which case, then the Senate will provide moderation, because it does that sometimes. In fact, it has to get business done, especially a major tax cut, which is automatic if nothing happens. You know, the leverage is on the Democratic side, because if they can obstruct the pre-Trump system comes back automatically. So they've got to veto, especially if they've got the House. They have to, you know, what will happen in taxes will be a compromise, guaranteed. You know, assuming they, you know, I guess you could do it with reconciliation, but I don't think you can do it permanently with reconciliation. And frankly, there are bipartisan solutions out there that should be brought up now, like I was saying this morning and this afternoon. You know, pass that bipartisan deal that the House came to. That's both, you know, good for the poor and good for the right to life, because it'll make sure people have money so they don't have to have abortions. That was the whole thing that was sold because I helped sell it on the Republicans, on the House side. If the Senate side now goes ahead and passes what the House passed, either in time for Trump to sign it, or for President Harris to sign it, maybe bumping it up a little for neonates. Yeah, that would be a good thing, and I'm knocking on wood for that, because you know that's one of the things that the Democrats put in, or the Republicans put in the last bill, to go from 1,000 to 2,000, but they didn't make it permanent. So they're all for giving benefits for families. So let's do that as job one. That is like the most important thing to do. Everything else is window dressing. That's video 4 for the day. I am going to do other things now.